Hi, my name's Tom Skinner of Barnaby Cecil. I'm here with my colleague Emma Walker, and we are going to talk you through the recent updates from the government in relation to the transitional discrimination of pension scheme members. It is a pretty dry subject, and we have read the document. It's 74 pages long, and we've set ourselves the challenge to provide you with the salient points in no less than 10 minutes. So, Emma, from the top, how have we got here? Bring us up to date, and what are the options now, or what's happening, and what are the salient points from the document that we picked out?
Okay, so background. Back in 2012, the coalition government decided that the current setup with public service pensions were too expensive, people were living too long, and that there needed to be a change. So they came up with the career average scheme, which is for the NHS pension scheme now the 2015 scheme. This was introduced back in 2015, and lots of members are now in that scheme or are transitioning over. However, because of the transition period, which was based on age, some judges and the firefighters took the government to court, and Judge McCloud ruled that it classed as direct age discrimination. So the government have had to produce a consultation to explain how the changes could work. They're looking for feedback, and they're trying to right the wrongs. Okay, over to you.
Okay, so what we are talking about here is anybody who joined the NHS pension scheme after March 2008 immediately went into the 2008 scheme. So that's the scheme that they're in. Those that have been working before that would have been up until 2015 in the 1995 scheme if they were born after 1965. If the individual joined the NHS pension after March 2012, their view is that individual had enough or sufficient notice that their scheme was going to be changed in 2015, and therefore they don't form part of this remedy period. So it's only for individuals who are in the scheme, whichever scheme they were in before 2012, have this are part of this consultation period and are affected. So that's the first thing. Those that are continuing to work in the NHS post March 2022 will immediately be put into the section 2015 and have their pension attached to the state pension age. So that's a very significant thing. That's something that I'd missed previously. I thought all members would have their pension benefits put back to a retirement age of 60, and they're saying that's not the case. Those that are still working after March 2022 can start to continue benefits then in the new scheme with a state pension retirement date. The period with which benefits will be considered and calculated will be known as the remedy period, and that's from 2015 to 22. And during that period, you will have a decision as to whether you want your existing benefits, whichever scheme you're in, to then be converted to the reformed scheme, which is the 2015 scheme, or up until 2022, your benefits to be recalculated based on the legacy arrangement that you would otherwise have had.
Yep, key point there is that it is legacy or reformed, and there can't be a combination of the two.
Yeah, so it's binary. You've got to choose which of the two, which option is preferable. They also introduce a concept. They discuss whether this remedy should be an immediate decision in March 2022. So therefore, everybody's going to make their mind up and decide what they want to do. And they discussed it in the document. They discussed the implications of that being that people will have to make decisions spanning 20-30 years based on their circumstances now, and they see some problems with that. But they also then suggest that they could introduce something called the deferred choice underpin, which will enable people to then decide at retirement which option is preferable. But the problem from a planning perspective, that means that the individual is then running essentially two very different schemes alongside each other without any sort of clear guidance, and it would be very easy to confuse oneself with which scheme that they were in at any given time, and also how their benefits were being accrued. So the deferred choice underpin option, whilst it does mean that it sort of shunts the problem down the line, or the decision down the line, it does make it much more complex, we feel. They go on to say that the decision is highly subjective, and the choice that an individual makes will have to consider factors such as whether there's an automatic cash lump sum in either the reformed or the legacy scheme, the age at which the individual intends to retire, the membership contribution rates are different in each of the schemes, ill health benefits and qualification for those benefits is different in each scheme, and entitlement to survivor benefits is very different in each of those schemes. So individual members will place different values on each of those different factors in each scheme design, depending on their personal circumstances.
Okay, another point to consider is the annual allowance tax. Now, if they are owed a refund in any period from 2015 to 2022, they will get a full refund. However, if tax is owed, and actually because of the choice they made, the annual allowance tax is actually higher, the 4-year statutory time limit applied by HMRC applies, and so whether tax actually needs to be paid will then determine, will be affected by whether they go with the immediate choice or the deferred choice. If someone's having to make the decision and knows, as of 2022 which one they're going for and whether they have any tax to pay, they'll have to go back from the 2022 tax year back 4 years. However, if they decide to proceed with the deferred choice and actually someone's not retiring until, let's say, 2030, well, if you go back the 4 years from there, it's not in the 2015 to 2022 period, and so it may be that they should have paid extra tax but don't have to.
Yeah, so they can only come after you for tax that's owed within the 4 year period. So another point there then to add is that they also say that individuals who sort of changed tack during the 2015 to 2022 period because of the prevailing tax position, or they took advice, let's say, they will review on a case-by-case basis whether that individual can apply to have benefits added had they not made that decision. So, for example, if a member has deferred membership for a period, has elected to not make an award pensionable over a period of time, maybe they came in and out of the scheme, what's called a hokey-cokey option, coming in and out of membership, they will review whether the on a case-by-case basis whether that person can apply to have those benefits added had they remained in the scheme. So you could have a case where there was a very, very significant tax charge 6 years ago, 5 years ago, and that would fall outside of the scope from what HMRC could claim within that. If tax is owed, the individual will still have the scheme pay option, so that will open up and they can apply to have scheme pays applied. So that's helpful for anyone who's paid tax. And this is really important. So if someone who's paid tax and wished to have scheme pays applied, they can then have that retrospectively looked at and potentially then have a direct tax charge if they would have scheme pay, but they were statutorily locked out because of a time period. During the remedy period, if you're owed tax, the 4 year rule doesn't apply. So if you change your benefits and then go it means that you now pay a lower rate of tax, then that individual can claim from the government the tax throughout any period. So I think we've covered most of the main points there. Have you got anything to add?
So I'd say the last thing to point out is that if they don't hear back from a member, they will assume that they want to continue with the existing arrangement. And so, yes, important to update NHS pensions with your address.
So not bad. Where are we now? 10 minutes just gone. So nothing's been decided. It's only going to affect people who were in the scheme after 2012 onwards. It's for a period between 2015 and 22. You may be able to make the decision, or you may be required to make the decision by 2022, or they may open it up and allow you to decide at retirement. There's lots of flexibility within that period for members to change decisions that they made formally and compare which they would be beneficial. And also those in retirement, anyone who's retired can have their pension recalculated back. So if you retired and had, say, 3 years membership, you can have that convert back into a legacy arrangement, which we've certainly got clients who are in that position. Nothing has been decided as of yet, and all members will be converted into or will move into the reform legacy as of March 2022. So I think that's it. 74 pages, largely repeats itself all the way through. If you need any further assistance, we're here. Stick Barnaby Cecil into Google and you shall find us. And as soon as we hear each of these salient points that we've discussed, when they get firmed up and an actual decision made, we'll be the first to tell you. Thanks for your time and take care.